which is that marriage is a fundamental right under our California Constitution. So the M word does mean something special. And even the opponents have to concede that, in fact, it does mean something special, and that's why they want it only for themselves and not for same-gender couples. But we are not going to allow the denial of a fundamental right. Domestic partnership is not a fundamental right. Marriage is. And my partner, John, would like to add something to that. John?
Marriage is universally regarded as a dignified institution. It's improper for the courts to decide who does and who doesn't get dignity. Dignity is a universal right that goes along with marriage. And what has happened here is that the people have voted to strip a segment of society of that dignity. And that is what is improper, and that is what we're going to seek to set aside.
In California?
Certainly, historically, we have had laws passed which bar sale of real property to minorities. We have had a whole series of laws which barred interracial marriage and things like that. Those are all the will of the people. However, they fundamentally conflict with the basic human rights that are guaranteed in our Constitution. So the people have broad powers, but they don't have the power to undermine the very basis of our Constitution and of our human rights.
The main point, I think the main point, though, is the ultimate will of the people is expressed in our California Constitution. That is the blueprint. That is the framework. That is the expression.
But this is an attempt by a thin majority to literally undermine the very constitutional basis of our fundamental rights. And the courts are the guardians against that kind of whim, against that kind of spur-of-the-moment action. We have transcendent constitutional rights, equal protection being one of the most basic of them. And that clause doesn't admit this kind of distinction. It never has. It never will.
We will fight back.
I wanted to say one thing, an answer to a question that I've been getting from a lot of people today about whether marriages that between same-gender couples who married between the time of our victory in May to date, whether those marriages are still valid marriages or whether they are null and void or voidable. That's one class of marriages versus the prospective marriages that may take place. Let me deal with those marriages that have already taken place, such as Robin and Diane's. It is our considered legal opinion that marriages which took place between the time of the published Supreme Court decision in our case and today remain valid marriages because the couples were married at a time when the California Supreme Court declared that it would be unconstitutional to deny a marriage license to couples of the same gender. That is our legal opinion. However, of course, the law is what the courts say it is. And so that will be an issue that the California Supreme Court will need to decide in our case, whether that class of marriages is still valid. And it's our belief that they will decide that. Now, as to any marriages that take place from today on, that's another group of marriages. And we'll have to see what the court decides. But we have those groups. There are still many people who did not marry before today who still wish to marry. It's our understanding the marriages have now stopped being performed in LA County. We think that's sad.
There's been 16,000 up to this point.
Because, well, they stopped. They're not performing them now as of today, and that is sad. And we don't think that they should have been stopped so soon. Having said that, it just emphasizes the importance of the lawsuit which we are filing with the Supreme Court today. And we shall overcome. The battle continues.